So welcome everyone to the Yale ISP's third in a series of 5 webinars, everything you need to know about the internet in 5 hours, which I have to kind of like stick a Twitter misinformation label on because obviously they're 5 90-minute sessions. I thought maybe they would like get edited down to an hour each, but they've been so substantive and gone on for so long that basically we've used the whole 90 minutes. It's been wonderful. So yeah, it's really actually everything you need to know about Section 230 in 7.5 hours. We are in the third of the series. The first 2 series was the history of 230 with Eric Goldman, Jeff Kosef, and Marianne Franks kind of talking about how 230 came into being and how it was interpreted by courts in its role from creating immunity from intermediary liability. Then on Tuesday, yesterday, we had what 230 meant for telecoms and agencies, which was a remarkable discussion. I've never been so interested in telecom in my life, with Blake Reed and Olivier Sylvain and Tejas Narachania. And then today we have we are going to be is the pivot point. We've had a bunch of lawyers and academics on talking about what 230 meant, but I really think, and this is obviously my bailiwick, it's insanely important to understand what's happening at the platforms and how they're interpreting the laws that shape them and how they navigate the space that the laws provide, and and how they navigate litigation that comes out of that. Comes out of the choices that they make on the policy front. So to that extent, we are joined by 2 really special guests, and we're going to be joined by a third. The first is Dave Willner. He was the head of content policy at Facebook from 2008 to 2013 and was primarily responsible for drafting what continue to be the outline of the community standards that Facebook applies today. We are going to be joined at 10 o'clock for the last half hour by his wife, Charlotte, who is going to be coming in and was there at the same time as Dave working in trust and safety. We have Alexander MacGillivray, who is got like the longest, most impressive tech resume you've ever seen for a tech lawyer. He was into tech before it was cool. He was the general counsel. You were deputy general counsel at Google, and then you were general counsel at Twitter from 2009 to 2013. You were deputy chief technology officer for part of the Obama White House, and now you have a cool new trust and safety organization that I hope that you will tell us about a bit, and that would be great. And so this is less of a mantle than you think it might be. We tried very hard to get a bunch of people in, but people are very busy these days. And so forgive us for that. I'm looking forward to Charlotte joining us. The format's going to go like this. We're going to do about 45 minutes of moderated discussion, and then you can be putting things into the Q&A. We will only take questions out of the Q&A. And if we pick your question and think it's on point, I will let you know via chat, and then I will rapture you in just by voice to ask your question to the panelists. That will be recorded. If you're uncomfortable with that in any way and prefer to have me read your question, I can do that too, and just make a note of that. But yeah, so 45 minutes of discussion and 45 minutes of Q&A. And yeah, thank you guys so much for being here. I really appreciate it. So Alex, why don't we, AMAC, let's start with you. You worked under Nicole Wong at Google, and tell us a little bit more about what your role was as a lawyer and how you found yourself working in tech as a lawyer, like what your path was. I think a lot of people, I have a lot of students right now who want to take that path and are curious about how that happened at any point, but especially interesting for those that got into it very early.
Yeah, I was really lucky is the biggest thing, and pretty privileged to come from a background where I actually could see what was going on. My mom had a business and used her computer, and that really got me into it. And that meant that I wanted to do internet law from the moment I got to law school in '97. I went to a firm and asked them if I could do internet law for them for the summer, and they laughed at me. And thought that that wasn't a thing, and certainly it wasn't a thing one should be able to get paid for.
They were still laughing at me when I tried to do it in 2017, so don't feel too bad.
Yep. Yeah, that got me to the West Coast, and I got to do, I think the first time I had a run-in with trust and safety and with content moderation was '99, when Third Voice, which was basically a post-it notes for the web, so you would put a post-it note on somebody else's website, got a bunch of complaints because people were putting post-it notes on whitehouse.gov talking about the Monica Lewinsky affair. So that was a very, very early introduction to this, but it had been existing even before that. And then when I got to Google, I kind of got to do, I had been teaching fellowing this course with Jonathan Zittrain on internet law. And so Google's pitch to me was, why don't you come do every single one of those things that you had been talking about academically? Which sounded awesome. And once Nicole came on some months later, we developed this thing called Product Council, which really sort of tried to think about what you might want to know from a legal perspective from products and help products get out there and launch. And certainly a lot of that was understanding content policies and working with Chantal Rands, who was originally part of the user support team at Google. We actually ended up bringing her into the legal department to start more of a trust and safety team. And she did all sorts of wonderful stuff to really establish trust and safety at Google.
Yeah, so can we talk a little bit about how Section 230 like interacted with your daily life at that stage? I'm very curious. I know Dave is not a lawyer, and we'll get to that in a second, because he's had a very different relationship developing internal policies in the space that 230 creates. But I am very curious as to, like, and Nicole kind of has this wonderful story, and she can't be here, but she has this wonderful story of really how the how do I put this? Like, that all of these sites, like, she was working for McClatchy, I think, at the time, and just people did not realize that everything was going to be content, and that the internet was essentially run on content and information, and how hard it was to get sites to transition to thinking of themselves in terms of the First Amendment, or in terms of communications torts and things like that, and put it what they might be liable for. So in that sense, how was that interacting with both, like, your time at, the stuff you were doing academically with Jay-Z, and then what you were you moved towards when you picked it up at Google?
Yeah, Nicole had this phenomenal book when she was working at Perkins that she put out that was
I have that book.
Content plus the internet, and all of the different cases and sites could fit into one tiny little book that could be updated every year. But that was a time that was different. There was a lot less law out there, and all of these services were just a lot less important. And certainly my memory from way back in the day was that that copyright and the DMCA loomed a lot larger than CDA 230. Because a lot of the people who were paying attention to the online space and were angry were people who had copyrights that may or may not have been infringed. So you look at some of the major battles back then, Third Voice, but also the early Google days where we established the transparency reporting through chilling effects, was around a DMCA takedown on the site Xenu.net, which was a Scientology criticism site. So there is something that, absent 230, might have been, there might have been another avenue for Scientology to try to come in and get that site taken down. But once 230 provides a shield for most things except copyright, they go in through the copyright window and try to get the site taken down through copyright. That said, the other place that I think it felt real was in a way as these sites started to become more important and more internationally relevant, you started to get complaints, particularly from England, but also all over the world. And a lot of those were defamation complaints. And they were looking for removal. It was typically powerful person against anonymous online critic. And they were looking to get the thing removed and to find out the identity of the critic. They were typically following a defamation route. They generally weren't terribly interested in actually suing the critic or in pursuing a defamation case, but they wanted the material taken down and they wanted the identity of the critic.
So it wasn't about damages. They just wanted kind of equity. They just wanted it down.
They often didn't have a case, to be honest. So it wasn't about damages, because if they had actually ever gotten to a court, the court would have told them that they had no case, even in a place like England, with a much less developed freedom of expression tradition in terms of defamation, especially. But they didn't really have a case. The reason why they wanted it taken down was to stop the criticism. And then the reason why they wanted the identity was often this criticism was from people who worked at the companies or worked with the people. And so what they wanted to do was to be able to take retribution offline against the person who had posted the information. And they were trying to use us as a tool for that. Fortunately, there's just a lot less litigation for a lot lower damages in places other than the United States. And so in a lot of ways, that developed quite slowly, while within the United States, where we did have many more people threatening, 230 was very useful. And the way I would frame it is not so much that 230 was something we were all walking around with and trying to be very clear about the contours of, and designing services to meet those contours. Rather, it was that 230 allowed for some freedom to be able to try to design the service that might be good for users and the companies. So and those services were radically different. I mean, you go from something like Google Search to a service like Blogger or Google Reader to something like Facebook when it arrives on the scene, or Friendster. Like these things were trying to do very, very different things. And what 230 allowed more than anything else is a freedom to try to make those things good and in service of the users.
Yeah, that could not be a more perfect pivot to Dave. But first, I want to say that one of my friends in 2005 went as a Friendster profile for Halloween. You just brought me back to that. Anyways, the development of Facebook, that's because we're going to pivot to Facebook, because it started, in 2004 and started with, as we all know this story now, among the Ivy League and just colleges, and then grew within a couple of weeks and months to other colleges, then grew to high schools, and was open to, and then grew outside the bounds of the United States, and was eventually open to everyone, and then except for age gating, I think. Dave, you came on to do Trust and Safety, having just graduated with your then girlfriend, Charlotte, who will be joining us later, then Carnival, now Charlotte Willner, to do Trust and Safety at Facebook. And you guys had just graduated from, Bowdoin. That's right. Yeah, and you went to San Francisco to kind of, she was like, let's do this crazy thing. I've got this new gig at this crazy new company. Let's go do it. It'll be cool to work for Facebook. And so you started to kind of do this.
I think this Facebook thing might work out.
I think this Facebook thing might work out. Yes. Listen to her always. So there's, but I just kind of want to flag something really quickly, and then I want you to tell us kind of like what your job looked like at the beginning and what it morphed into, because I think it perfectly illustrates what Alex was just talking about. But I want to say something about trust and safety, which is just that, like, there was this discrepancy, I think, and you guys can tell me if you agree, between calling things trust and safety, which was dealing with consumer complaints about the type of speech they didn't want to see or wanted to see, right? That was considered trust and safety. It was almost considered like a customer service type issue, especially at the beginning. And contrast that to kind of the hard, I would say, the more IP-driven internet law of DMCA and IP and things like that. Alex, you think that that was different? Those were all the same thing?
Yeah, I definitely do. I'd be interested to hear what Dave has to say about early Facebook, but certainly early Google and Twitter, we thought about, there was certainly a user support area. I'm having trouble resetting my password might be a good example of that. And then there was trust and safety, which was much more of a one user, usually against another user. So some user says something, some other user doesn't want that to be said on our platform. And that is kind of the dividing line that I usually thought about there. And so you didn't have the it wasn't, it was much more of, there was much more tension in those types of interactions. And then those tended to be things that really defined what the product was. The Facebook's real names policy is a great example. That was something that really was a defining thing about Facebook, and the people who enforced that real names policy and did the back and forth there, to me would have been trust and safety, but I have no idea.
No, that's like, I think that that's really important. But you would put like the IP claim, like IP issues, or like, would you put that separately too?
No, certainly
Is that
DMCA was coming into the same stuff. Something like Apple thinks that Google is infringing one of its patents. That was handled separately.
okay?
But something where it was one user was saying that another user was infringing their copyright or their trade secrets, which we got plenty
So
of those.
every user v user claim basically was handled by trust and safety. Okay, that makes a lot of sense. Thank you for clarifying that. Dave, so tell us about when you started in 2008 at Facebook, what the rules looked like, how they were doing this.
Yeah, so I actually didn't even start doing trust and safety. I started resetting passwords because the iPhone had not been invented. So there was no way to do that other than emailing a person, at least not on Facebook. I suspect the sort of divisions you're looking for develop differently at different companies and also depend on the phase, right? So when I started, it very much was sort of a big pile of CS, customer support related stuff, because at the time you could still email Facebook and get an answer to a question. Then there was a small group of people who dealt with IP stuff where they were very heavily connected to legal because of how much of that was governed by DMCA and other legal sort of issues. And then there was a small but rapidly growing group of people who would become trust and safety, although at the time we called them site integrity, who dealt with both the user versus user complaints and spam and phishing and fraud. As stuff developed over time, we just ultimately solved our support backlog by not answering questions anymore. It was an innovative approach. And all of the folks who had been doing CS got converted into some version of trust and safety, or IP, or sort of bugs and more technical support. And then within trust and safety, there were differentiations between the sort of more hate speech and more interesting content policy related areas. The security and spam folks would face engineering much more closely. And then the sort of biggest group, which was dealing with all of the naked people, just because nudity is by far the largest volume driver in a lot of these spaces. And there are interesting parts of it, but a lot of it is really not very interesting from a substantive content point of view, because it's commercial pornography. It's essentially another kind of spam. And that was by far the largest volume driver. But as we grew and as we internationalized, there was that divergence. I think AMAC nailed it towards the end there around what 230 meant, because at least the message we were receiving, and again, not a lawyer, just an anthropology major who works with a lot of lawyers, was that IP and defamation stuff needed to be handled very closely with legal, but on the rest of it, as long as we were within the terms, which said we could do basically anything we wanted, we could do anything we wanted. And that converted the question from a legal question into a philosophical or almost existential question, where we spent a lot of time thinking about, okay, what is Facebook for? Because you needed, absent a constraining law, you needed some way to get all of these moderators and decision makers and PR people and public policy people and other people in the company with opinions on the same page about what you were going to take down and what you weren't going to take down, so that you could all stop fighting and like go do moderation. And so it became a debate about finding that unifying thesis, whatever it was, in this case at Facebook, but my understanding is very similar things ended up happening at Twitter and Google and other places.
You gave an analogy once that I want to highlight, that about the, speaking of anthropology, about the development of all of the different sites, and you compared them about how they developed wings.
Mm-hmm.
I think you said that, you know, they were all of this was happening at the same time, but some developed bat wings, some developed, you know, bird wings, some developed, you know, like fly wings. And so it was this very, like, there's all the same, serving the same function, but developing in slightly different ways, which I thought was a kind of a good way to think about it. I'm curious what you think that the changes that started to happen to the happen internally at Facebook and externally in its user base that drove the development of the community standards into, as I understand it, you started with a one page, if it makes you feel, if it promotes Hitler and if it makes you feel bad, take it down, and moved to a 90-page-ish wiki that was developed, that was kind of internal to the company, which are the secret rules that were kind of behind all of the community standards that had examples in them and things like that. I would love if you could just talk about kind of how that just started to develop. You were working with Judd Hoffman at the time. He was a lawyer by training. How did the two of you kind of work together? Was he concerned about Section 230, or was he also just kind of very focused on kind of creating a consistent rule set to kind of apply to these problems?
Yeah, so it was a very interesting path, right? One, I had started, there were only about 12 of us doing moderation for the whole site for all kinds of subjects, and the rule set was similarly sparse, but it essentially was a list of like consensus decisions that the group had reached that they then wrote down for stuff that came out a lot, right? So the origin of this was less some philosophical treatise. It was basically an FAQ of like, we see a lot of naked people, here's the rule on naked people, because this is going to come up a lot. You see a lot of Nazi stuff, here's the rule on Nazi stuff, this is going to come up a lot. And as I started around the time the site had just moved past networks, that sort of idea of high schools and colleges being these networks you were in, because it didn't work as the site went broader. And after the sort of network architectural baggage got dropped, the site exploded internationally. And that meant that we moved from a place where hire a bunch of college students to moderate this, because you're basically moderating the content of college students and pre-college students in the United States, which, you know, isn't the most rigorous plan in the world, but it like worked fairly well, to a point where you're having to understand the like history of Eastern European treatment of the Roma to be able to understand what you're even looking at, because it's in Serbian and you're trying to read it through Google Translate, which isn't super great on Serbian even now, particularly not back in like 2009. And that evolution drove a need for a lot more of those sort of, this is what we do here kind of answers. But that became unmanageable, right? A big list of do these things is not a plan. And so we essentially reverse engineered, a number of us got together and did a project where we reverse engineered a set of rules out of the answers we had gotten at, under the assumption that there was some implicit logic operating, and we wanted to make it explicit so we could then reform it. And that was the origin of that set of standards. It was like, what is a policy you would write that would generate this set of outcomes, and what implications does that have? And do we actually think that's good, like in terms of fit for purpose for what the site is? That process happened, at least at Facebook, sort of simultaneously and semi-independently in user support, in the team that dealt with ads, which was a separate group of people, and in the team that dealt with developers, because at the time the platform already existed. So there were also all these questions about like, what kind of apps would you allow? A number of us sort of evolved into being the people who managed those documents. And then at one point they said, oh, this is probably a team and they hired Judd to turn that from a group of folks doing things into a team. So Judd came in at the point where there was already some structure, but brought obviously that sort of legal background and more thinking around, okay, let's build this out into a cohesive whole, not just three different sort of competing frameworks. Honestly, though, we didn't like what 230 meant is we didn't have to talk about the law that much. And so it wasn't a major presence in what we did, except as a set of guardrails, right? It was a guardrail around how you approach content takedown. You didn't edit, you removed things. It was a guardrail, its limits were a guardrail around certain things like IP or other issues where there were either holes or potential holes given sort of, international defamation, et cetera, et cetera. But it largely meant the conversations were driven by what the product was for. And frankly, we spent a lot more time talking about what openness and connectedness meant in practice and how you balanced allowing people to say whatever they wanted with not allowing speakers to be excluded from the conversation, since those two things compete, than we did about the law as such. And that's what it meant. It meant that freedom to think about the site as a unique thing, as opposed to a Google or a YouTube, which were different and had other purposes.
Yeah, Alex, do you want to say something about that, or?
Yeah, I was just going to say, like, I think as some of those concerns from trust and safety would get escalated, probably the most prevalent one in the early days that we might have had to take down if 230 did not exist would have been defamation.
Mm-hmm.
The amount of powerful people who didn't like what was being said about them online has always been a lot. It does not go down. And the cudgel that certainly we saw a lot, and 230 provided us with a backstop, especially in the United States, was really around defamation.
Yeah, that totally agree. And the thing, at least for us, that came next was government complaints, particularly as we internationalized. Where, technically through 230 doesn't protect us necessarily in those other countries, but in practice meant we could sort of put up a fairly strong resistance.
Yeah, so I want to talk about, and you've both touched on this a little bit, about the international nature of the platforms. And so what I'm curious about is, and Eric, you actually really explained this very well, which was just like the civil liability that is on that is threatened because of communications torts in the United States is much greater than that allowed in other places, and so 230 was particularly important. But as kind of right now, like Facebook's user base is 8 to 9% American, right? In that context, you hear people saying that maybe 230 is not as important. That, of course, kind of query the fact that not every, and in fact, most websites are not Facebook, and then, or as big as Facebook. And then kind of, so do you want to talk a little bit about, how you feel about 230's role today in terms of in this very transnational world that we're all living in, where we understand that all these platforms are transnational, and then kind of talk a little, I'm just kind of curious how this all ties into kind of a lot of the antitrust conversations that come up, where I feel like the same people who are moving for antitrust type of action want to get rid of 230, and those seem at cross purposes because it would really just take out some of the littler platforms that start with defamations, like by putting them at risk for defamation suits. So any thoughts about that?
Yeah, I think I think you're totally right that 230 is like an incubation helper. One of the major changes from going from Google in 2009 to Twitter was really two things. One, Google was really big and impactful all over the world, and we were starting to have good effects and really bad effects all over the world. And so we were talking to governments as Dave said, we were talking to governments all over the world, and we could make mistakes that would be extremely bad, both from a user perspective and from a company perspective, all over the world. And people were back then at least, starting to take Google to task for a lot of that stuff as well. moving to Twitter, first of all, the pressure went way down, but also Twitter at the time was much more US used, much less important. And what 230 allowed us to do with only US employees, only a US corporate structure at that time was, yes, we're going to worry about the rest of the world, but we knew that we couldn't do anything absolutely horrible from a legal perspective with respect to the rest of the world yet. And yet, in the United States, we did have that incubation shield of 230 to allow us to experiment with some stuff without, having to have 1,000 people doing content moderation, or a fleet of attorneys reviewing a lot of different things. Twitter at that time was somewhere around 60 people, 1 or 2 attorneys, depending on how you counted us. And Google at that time was, I'm going to get this wrong, but I think it was on the order of 125 attorneys, maybe more. So that's like it did have a huge, just as you suggest, incubation helper effect, because it allowed you to be a little bit more small and nimble while you were less important.
Yeah. Daphne Keller, who is one of your colleagues at Google under Nicole, and is now at Stanford Cyber Center, I think, I always lose track, could only come for a little bit today, but has a great question. So Daphne, the floor is yours.
Hey, thanks for letting me jump in. First, Alex, I have to say I love your shirt, and I hope you will talk about the importance of that shirt later. The Trust and Safety Tyrannosaurus Rex and Unicorn team shirt.
Pretty good.
The question I wanted to ask is about spam. And it's sort of like, first of all, like what is spam? Like, what did spam mean to you on the 2 different platforms? And what is the conceptual difference between content that you take down because it is spam versus content that you take down because it violates a content guideline? And how the need to fight spam shaped what you did, what you could do, or what you chose to do in ordinary content moderation.
Awesome question. Dave, do you want to go first?
Sure. Yeah, so spam is interesting because it, I think, is used to roll up a number of things that are problematic for different reasons, right? So there's what I think of as the easiest part of it. There's your sort of phishing and malware distribution, which is definitionally problematic because you're trying to compromise people's information and steal their identities. That stuff is hard to fight, right? But within the corpus of spam is relatively straight up and down from a content neutrality point of view. The things that aren't that, and that was particularly relevant at Facebook because we were, at least early on, not a great monetization channel, but we were a very good spread channel because people would try to compromise user passwords. And then you could basically run a 419 scam, like a help, I'm stuck in Nigeria, send me money, or I'm a prince, give me your bank account number, from somebody's friend, which was much more credible, right? You were hijacking the social credibility of Facebook. So a lot of the stuff we were dealing with were attempts to compromise other accounts on Facebook to then later go on and try to monetize somewhere else. So that was obviously more straightforward because you don't want people to get into accounts that aren't theirs, is a like pretty basic common sense and unifying principle. There was also spam that was more traditionally what we talked about is advertising in the wrong place at the wrong time and often in too much volume. Right, so it was, we were comfortable obviously with ads, but they needed to be contained, and also frankly the company wanted to get paid for them. And a lot of what became spam was often fake accounts, but even sometimes real accounts repeating the same commercial messages in channels that were meant for organic content. So it was less about the substance of the message and more about its aim and its frequency. And a lot of the spam detection was frequency based, which would later go on to cause problems with political speech when people were trying to push the same message in a lot of places because it looked very similar, at least initially.
AMAC?
I think I'd love to hear Daphne's answer to this question too, since she was the product counsel for web search, which had a whole spam team. But I don't know if she is still on, but what I would say is it's all one continuum, and it is all about the product policies. Spam tends to be the things that we care less about in terms of false positives, as Dave just gave some examples, but also Facebook didn't care as much about false positives on nudity, and so that was another thing that as Dave said before, Facebook considered spam. Other places I've worked have not considered that spam, but the spam tended to be more algorithmically addressed. And I think that was because, although these are just content policies like any other, the problem of goofing them up by removing too much stuff was less important in the spam area than in some of the other areas.
Yeah, totally. It's also worth noting there was more of a developed industry, at least when I arrived at Facebook, around sort of spam and malware prevention. That sort of site integrity, security oriented lens had older roots going back into email. And so there were developed professionals who knew what they were doing, who were sort of in charge of that broad area, and that aegis extended into spam, at least at Facebook. So it got sort of classed mentally into the security things bucket more than it did into the pure content bucket. Obviously an artificial distinction, but did matter in terms of the approach, because those folks tended to have more engineers to write algorithms to do things automatically.
Daphne's still here, so Daphne, go ahead. And I would love to hear what you have to say as well.
Yeah, it's funny. I think I'm actually more in Dave's camp and less in Alex's camp, even though Alex and I worked at the same company. In web search, something is spam not because it is poor quality, because sometimes people are looking for poor quality things, or they're looking for porn, or they're looking for bad jokes instead of good jokes, or whatever. If they're looking for it, then that's the right result. But it's spam if it's not what the user was looking for. And as Dave said, like, it's usually the product of somebody who's trying to game the system. Like, there's this security-like component to it, where there is a bad actor trying to game the system to get the wrong, quote unquote, wrong content in front of the user. And so, it's spam because it is something other than what you think the user was looking for, not because of necessarily a judgment on its quality or, decency or whatever as content.
That makes a lot of sense to me. Thanks for your questions, Daphne, and for hanging out to kind of give us your perspective. I have something really quick. If you can stick around for one more question, I have a question for you, Daphne, and I was again for AMAC. I totally shanghaied you into like being a panelist when you were like, I'm really busy, I can't do it tomorrow, I'm sorry. Anyways, I'm just really curious, like this highlights something I've always wondered, which is that like Facebook seemed to have like more or less one product until it acquired like various things like Instagram and everything else. It just seemed like one thing, especially with newsfeed and disaggregating from networks. Alex, Daphne, like it just had to, like, you just are serving like the community standards of YouTube, a video platform, would just seem like where just lengthy scroll. Like, I don't even know, I've never really completely gotten my head around how you do content moderation on video well. And maybe you don't is the answer. But then web search, as you bring up, Daphne, completely different set of questions, not about bad and good, not about quality versus non-quality, about like providing what the person wants, like that, like being able to basically kind of just connect them. How did that impact the way, like, how did that impact how people working on content policy, were they siloed in their respective projects? Did they come from one thing to another from similar project? Like, would you go from YouTube, working at YouTube, to going to work at Facebook Live? I'm just really curious how that progressed.
Maybe I'll answer first because I'm the one who's trying to leave. You know, I think, you know, Google, because it had such just a fleet of different products that truly had different purposes, for a long time, those products had their own different content policies. You know, like the content policies that you want for something like Google News are going to be different than what you want for Blogger, and different from what you want for Reader, and different from what you want for somebody's, you know, Google Docs diary page. And so, you know, and that creates all kinds of inconvenience, having within the company a bunch of different approaches to content. And over time, finally, you know, those got consolidated in ways that inevitably sacrifice some of the values that were important to one of those products in the first place. And I feel like I think about that a lot these days as we talk about, on the internet writ large, different platforms converging on the same policies, and whether that's a good idea or a bad idea. And I think it's a bad idea. You know, like, there are reasons that Reddit has one set of policies and Facebook has a different set of policies, and that's a good thing. And it gives us both just like a diversity and plurality of discursive communities to join, but also just different rules make sense depending on what your platform is for.
Yeah, I completely agree with that. But AMAC?
Yeah, Daphne's right as always. That's a good rule to live by. The only thing I would add is that you know, that was a real thing within Google, particularly as we developed more and more products. Because when I joined Google, it was ostensibly a one, maybe two if you count Google Groups, product company, and being intentional about what the right content strategy and content policy strategy was for each product was a really important part of those products' success or failure. Google Video, which was something that Daphne and I both worked on, although I was part of the failure part and Daphne more on the success part. That was a place where our content policies really were part of why we lost to YouTube, and eventually why we bought YouTube, was because what we were thinking was, well, we need to make this especially friendly for the content industry. We need to make sure that the people who develop HBO shows want to put their stuff on Google Video. If not, there's no real product there for them. And so as a result, if you wanted to upload your cat video, it took you a fair long time, because we were reviewing them and trying to make sure that it was not copyright infringement, which is a whole is a bad idea. But YouTube wasn't doing that, because they weren't trying to make another place where you could watch HBO. They were trying to make a place where you could upload your cat videos. And so they knew that being able to upload it and immediately share it with your mom or your significant other living far away, that was what was important. And so they really prioritized that differently. And that was one of the reasons why they were so successful when Google Video was not. And I think that's one of the things that's really tough for companies that are trying to fit very, very many products under one brand. And to me, this is part of the Facebook story and their current issues, is that you've got a whole bunch of different user expectations of different modes that would be perfect for those users. And you kind of cram them all together under one brand, and so users come with all sorts of different expectations about what they should be seeing. Is this more like a library where I wish they have almost every book and I'm not going to get upset if they have a book I don't like? Or is this more like a dinner party where if someone drones on and on about a subject that I don't care about, that will make me not like the dinner party? And that's a really big question going forward about how do you do some of these things. I don't think you can really be all things to all people.
Yeah, I mean, 100%. And that was something, I mean, Facebook was, as everybody's implicitly pointed out, one product that they just sort of stapled more functions onto, right? The way it was thought of as was the core product was like basically it was a holodeck, right? It was like you were you inside the internet, and now we're going to bolt more things you can do inside the internet with your real identity onto this product for a very long time. The Instagram acquisition didn't happen until about a year or so before I left. And even then it wasn't really that different. It just had filters. The live stuff, WhatsApp, which seems much more complicated, happened later. So for us, it really was very much an attempt to cram everything into one product. And that very quickly meant, we very quickly realized the only thing we could do was reach a fairly disappointing compromise to everyone. It's sort of the inverse of the democracy. You can't please all the people all the time, but you can mildly disappoint all the people all the time. And literally compromise, and moderation's the wrong word, but sort of compromise between the various forces pushing on us became the goal, and which is not a recipe for building an approach to content moderation that anyone likes. But when your audience is everyone doing all the possible things they could do on the internet, like, that's probably impossible.
Yeah. I think that this is actually a perfect segue. Zoe Dorme, who is formerly at Facebook as well, just left, who is working on the oversight board, writes in to say that this is the opposite of what regulators are trying to do, which is retrofit a one-size-fits-all rule on companies. So they're writing rules to account for Facebook or UGC, but not always considering how that works for cloud-based file sharing or private chat groups, et cetera, et cetera. I think that's a wonderful, wonderful point. And it takes us to some breaking news, which is basically that the Senator Schatz and Senator Thune have introduced are going to be introducing, I think if they haven't introduced it already, they're introducing it today, a bipartisan bill called the PAC Act. I actually don't know what the PAC stands for, but it is to try to mandate national call centers to deal with takedowns at companies, and 14, I think it's like a 14-day or a 7-day turnaround time on getting people resolutions on their what they're upset about on the internet. I think that it's a well-intentioned bill. This is certainly not kind of political theater like the executive order was, or Senator Hawley's act was, or motivated in some way. I think that they generally are trying to do the right thing here. But this just, I literally could hear a laugh track behind. But when I was reading the bill, how is this even something that seems feasible to you, AMAC or Dave? Does that even parse? Does it even make sense?
No.
I mean, why not? I mean, more specific. I mean, you haven't looked at it, so.
Right, I have a lot of questions. Do they literally mean call centers, like with a phone call? Because if they
let me look up.
I'm pretty sure it logistically can't be done.
Subject to subsection E, making available a live company representative to take user complaints through a toll-free telephone number during regular business hours for not fewer than 8 hours per day and 5 days per week.
Yeah, that's not possible.
Yeah. Why?
Because Facebook gets hundreds of millions of complaints a year, and even with only 8% of the users in the United States, that's a whole lot of phone calls to take. Phone calls are very, very slow compared to the way they do moderation now. This is, in my new life at Airbnb, I've learned a lot about phone calls. They're basically the worst. And they're not a great way of solving moderation challenges, and they frequently are very disappointing to users because you often have to go offline, go find a bunch more information, then come back to people. And they are one or maybe two orders of magnitude slower than direct content moderation. Now, I doubt moderation-based phone calls would be quite as bad as what we're dealing with, because we're dealing with more complicated transactional cases at Airbnb, but I'm not actually sure it's logistically feasible to do that. I would be very surprised. And if you could, it would take a very, very large amount of money.
Yeah. AMAC, do you have any thoughts, or does this seem like, do you have any, I mean, both of you, I mean, you in particular, I'm really, since you've worked both inside government and at companies on these issues, do you see is there any low-hanging fruit in terms of legislation that would be a better solution than this?
I don't know, because I haven't seen the bill, but the thing I would say is that there are a bunch of things that are actually illegal currently in the United States that we're not enforcing very much. And the more you dig into some of the complaints here, the more you find that there is actually a way to get the content removed and pursue the bad actor. And child exploitation is a great example of this. And so I personally think that a lot of the low-hanging fruit is getting some of the laws that we already have on the books and ensuring that we are actually using them. And the thing I like about that approach is because those tend to be things that we all agree on. Or at least where many of us agree. One of the things that's really hard about this most recent spate of calls for more and less content moderation is that any particular call is often something that is very specific to the individual calling for it. They think it's a good idea, but very few other people do. Or maybe half the country does and half the country doesn't. And that's just, I think, a very hard place to start. Maybe we'll get there someday. But I would be, if I was looking for low-hanging fruit, I would look to the places where there are already laws about the content, but we are having trouble actually getting to enforcing them, either in the physical space or in the online space.
So to that end, one of the last things that I went to in person before the pandemic was a Section 230 DOJ hearing in February that seemed to be in which there was like National Center for Missing and Exploited Children, and there was, there were all types of kind of people represented, and some saying exactly what you're saying, and seeing as the the but-for cause to there not being more of a solution to problems of child exploitation as the rise of encryption on various platforms, and it's and Signal, Messenger, WhatsApp, all of these levels of encryption. And so I'm curious. Of course, then you had, people talking about Hong Kong and the fact that all of these protests and all of these moments for democracy, when you have strong authoritarian governments, are made possible because of encryption and being able to protect your privacy from police. Kind of this, this hand in glove idea of privacy protects freedom of expression in a lot of ways, at least via the government. So I'm interested. I agree with you that there is like a tremendous amount of bad acts still happening that are just better enforcement on illegal conduct that could happen. But I don't know. I'm still very split on encryption and getting whether there should be a ban on encryption. I don't know whether that would even be legal under the First Amendment, but I'm curious about your thoughts on that. Like, how do you think that we would just be better writ large at taking down illegal content if we didn't have encryption? Is that where you see the problem being?
I don't know if you're asking me that question. I did work on this when I was in government, and I worked on it since government. And I don't think that's the case. You talk to somebody like Susan Hennessy, who is a real expert on child exploitation and the use of encryption in and technology in child exploitation. And she wrote a paper a little while ago that also argues that these are very technically sophisticated folks. They will get their hands on encryption. So I don't think that it's a solve. Just like real names do not make it so that everybody behaves. Lack of encryption does not mean that everybody that you can see everything, and it doesn't. And encryption itself, there are still millions and millions and millions of reports to NCMEC, for example, that are happening even with encryption. So I don't think that's the crux of the encryption battle. To me, the crux of the encryption battle, and I'll try to bring this back to trust and safety, but the crux of the encryption battle is that we don't have a good technological solution that would properly balance the trade-offs in society between platforms being able to see all the things that you write and on the one hand, and the privacy and police interests and all the other interests that are on the table. The Carnegie Endowment for Peace, along with Princeton University and me, convened a group of people to talk through that. We have a whole paper on it. I can put it in the show notes.
Yeah, please do.
that we're trying to say, like, what is the right way forward. But a lot of it is about actually better understanding the technology and trying to figure out whether there is a way to develop something that would bring all the equities together. And to bring this back to trust and safety, I do think what is missing a lot in trust and safety discussions, particularly at the legislative level, is an understanding of the nuts and bolts of doing some of these jobs, such as content moderation. And so having people like Dave really, be able to speak to, oh, is that actually feasible? Well, no. Okay, so let's start with having a law that is feasible, right?
Or not just feasible, like just a lack of resources. Like maybe you could set it up, but it wouldn't be effective for what you're trying to do necessarily.
It would be less than useless.
Okay.
Like, we'd actually be better served giving everyone the same amount of money to burn in their houses for warmth.
Okay. I won't tell Senator Schatz that. I think it is actually, I think they're trying to do the right thing. They are trying to get at something,
sure
but there is like a huge gap in information here. Bruce Schneier has this wonderful quote that I really love coming back to, which is just like, policymakers need to understand that technologists are capable of building worlds, and technologists need to understand that they are capable of building worlds. And I kind of think that is exactly true, and really gets at the delta between why we're getting bills like this and why we are having conversations like this. So I'm going to go to Blake Reed in a second to ask a question. But I just wanted to say really quickly at the top of the hour, as we're about to turn to 1 o'clock here, we have 30 minutes left. Please put your questions in the Q&A. Charlotte Willner should be joining us shortly. She is wonderful, and it is interesting to hear her perspective alongside Dave's. They work in slightly different roles at the same company. And I also wanted to say that tomorrow, if you're going to plan to tune in again, we are starting an hour later at 1 p.m. Eastern time because of a conflict. It will be recorded if you can't make that. So, but we're starting from 1 to 2:30 tomorrow. So please tune in then. And Blake, you have the floor. Thank you.
Thanks, Kate. Hey, Dave. Hey, Alex. Really appreciate the conversation. Teeing off of what you just raised, Alex, you seem to suggest that any of the sort of policy interventions on reforming 230 kind of get into fairly controversial territory, but there's some fairly well settled areas of law, anti-discrimination law. So think about the Fair Housing Act or the Americans with Disabilities Act, or our tort law, thinking about products liability, where folks have tried to lever them against the platforms, and the platforms have been quite happy to insert 230 as a barrier. What do you think about that? Is there any room for reform on those issues? Are we ultimately going to end up in substantive fights about the causes of action that folks are going to bring?
We'll end up in substantive fights about the cause of action that folks are going to bring, but that shouldn't stop us. I don't think, I wouldn't say so first of all, like I became a lawyer in 2000, and I'm very much part, I think, of the older guard. And to a certain extent, you just shouldn't listen to the older guard, right? We should be going forward and trying to make things better. And I've done jobs like this for almost 20 years, and there are plenty of people with newer, better ideas. So just to start with, I would say that. The second thing I would say is, which feel free to ignore, is yes, we're going to fight about that stuff. That doesn't mean we shouldn't be thinking about, are there reforms to 230 that would work and make the world better? For my part, I would be cautious there because the stakes are high. And in particular, I would think a lot about the smaller platforms and how to make sure that they are still able to exist and flourish. I would think about new ways of doing things and making sure that they can exist and flourish. And I would think about, and this is something that Daphne has actually done a tremendous amount of good work publicizing results, where the more and more we allow people to have power with respect to removing content online, that often, though we set out to do that for very noble goals, in order to protect and give power to communities that are generally not as well served in the real world, underrepresented folks, that often backfires, and it turns out that we are giving more power to the more powerful. So those are the types of things that I would be concerned about. But yeah, listen to the younger, newer folks.
Dave, do you have anything to add?
Yeah, I mean, I think all of that's right. I'd also say, being at a company now that worries quite a bit about the Fair Housing Act, although arguably could shield itself using 230, the existence of 230 has done nothing to change how freaked out we are about that issue. And I suspect that will be true around a lot of those kinds of topics of essentially all of the good faith or larger actors in the space. So there is that to consider, right? It's not a 0 or 1 thing. Social shame and pressure absolutely works quite well in many cases. The other thing I'd say, just picking up on Mac's theme about the danger of these powers, my strong view is that as these systems have become more developed, they've become less democratic in the sense of being less equitable. I think you're seeing a version of that break into public with Facebook's stance around politicians and the sort of separate set of rules they have for lies and hate in speech by explicitly elected officials. But just in general, as the systems have ossified, right, they're administrated by people, and those people don't come from nowhere with no social connections or biases. And so there has been a tendency, in my view, for existing patterns of social hierarchy to reassert themselves as these systems in general become more developed, which is maybe not what everybody wants to hear, but seems pretty clearly true to me.
Yeah, the research around right to be forgotten in particular really backs up that point of view.
Can you say more about that, actually? Because I've been fascinated by some of. I thought that the transparency report that Google put out around right to be forgotten was just one of the most amazing documents about kind of just looking at kind of some of the volume of cases. Were you? I don't know. You were gone from there by the time that all happened, right? But do you know anything about how that happened?
I was, and Daphne is a really good resource on this stuff, right to be forgotten, and other takedown regimes that and whether they sort of who they impact. And there are a lot of really good case studies exactly on this. So if Daphne's still on the chat, she would be great to talk to this. In my experience, it often it is the powerful that just get more powerful, and so we want to make sure that we're not just repeating that mistake. I think if you look for somebody else who's doing really good work in this space is Danielle Citron. Really is. I mean, I disagree with her on a bunch of stuff, but she is doing amazing work at trying to get to the right end result. And that's what we all want. I think we all want for this to continue to improve over time. No one has really cracked the riddle of how you have hundreds of millions of people all talking on the same platform and
About each other.
Yeah, about each other, and have it be actually something that can work and be equitable and bring us to a better place than what the world is now.
Well, I just want to say, I'm going to go to Thomas to ask this question, but we now have Charlotte here and Evie. I think we are now a very gender balanced panel. And an age balanced panel even. So we are not ageist here. Although I'm pretty sure that I should have had her sign a consent form or something. Okay, it's so great to see you, Charlotte. Charlotte was, as I said before, at Facebook at the same time Dave was, and now is at Pinterest, so she'll be speaking in her capacity of her time at Facebook. But it is great to see you. Thomas, go ahead and unmute yourself, or I think you're unmuted, and go ahead and ask your question.
Thanks a lot. This is really excellent and makes the pandemic so much more pleasant. My question follows on what Kate alluded to earlier, which is that these platforms today operate really globally and it's subjected to regulation in all kinds of countries. And there seemed to be a suggestion in early remarks, I think by Dave, that Section 230, at least in the beginning, used to be helpful in some way to counter regulation coming from other jurisdictions. And I was curious why and in what ways that materialized, and maybe then building on that, I'm really wondering whether that's still the case, or whether the trend is simply towards a world in which we will maybe have to accept that different jurisdictions have different views about what should be permissible on platforms, and then leading to a world that embraces geo-blocking.
Yeah, I can, given that I introduced it, I can sort of take that. So there's a couple of things going on there. One, the combination of 230 and the First Amendment means that it's very hard for other governments to press the United States government into helping them when they want to enforce laws or takedowns, which essentially turns the entire conversation of international law into a giant game of chicken, because the question is how far a given country will go to enforce its rules, not really what the rules are per se. And I do not think that would be the case if the United States had a legal regime more like England, say, where it was in a cooperative place with the Germans and the French and a number of other things, or another number of other countries that have more restrictive rules, and the United States was more open to them. So it's less 230 per se and more the space from the government being enlisted by other governments that it creates. I'd say that's still true. The big problem with the regionalized view and the difficulty with adopting geo-blocking to solve everything is that these products aren't regional, right? There's no Germany on Facebook, there's German people. And they can speak to Americans and Turks and the Dutch and people in Hawaii and, you know, wherever. And the question becomes whose rule sets apply in which conversations. There are some products where that's not true, right? Google has its various national sort of search portals, but even then, the sort of European view is like, that's not good enough, we want the global one, because everybody wants their rule set to apply everywhere to everyone. But what that ultimately means is a race to the bottom where the most restrictive rules win, which I don't tend to believe we really want either.
Yeah. So we're running out of time rapidly. And I want Charlotte to kind of talk about her time in trust and safety, and tell some fun stories. You have so many of them, honestly. It's like going out to dinner with you guys is like this weird, like when Dave tells stories about like the start of Airbnb beginning to do experiences and deciding that they were going to strap someone was going to offer hot air balloon rides in a hot tub. And like as like a lawyer, I was just like, oh my God, like that's the worst idea ever.
About that is that in the hot tub, the operator of the hot air balloon experience also has to be with you. And so it's not even this romantic notion. You've always got the guy next to you, right?
Yeah, have a hot tub balloon ride with a stranger. Anyways, thank you so much for coming in. I want you to talk about trust and safety, and that will be a really, really lovely pivot, actually, to Alex's new venture, which I think is just awesome. And I want to also distinguish, it is about kind of supporting trust and safety workers and not about creating some type of, as Daphne talked about earlier, some type of universal standard of trust and safety for the companies. So Charlotte, go ahead. Hi, Evie.
I apologize. I mean, clearly life is happening. I was on a team meeting that really needed to happen before this, so sorry to be late. So trust and safety, I've been working in the trust and safety field now since 2007 when I started at Facebook, and I am at Pinterest now. What has really emerged, and this is very relevant to the 230 discussion, right? What's really emerged is the role of the moderator and how to some degree, human moderators are always not only going to be with us, but going to need to be with us, and how we grapple with that as a global society in terms of how do we treat our moderators? What do we expect from our moderators? What tools do we equip our moderators with to help them do the best job a human can do, understanding that it's, in some circumstances, always going to have to be a human. And that's where, support organizations like, I think we're probably going to talk about a little later, come into play. But, in my experience, it takes and this is going to be the moderator's plea, it takes a special sort of person to be a moderator. It is people liken us to garbage collectors and all, and police, and it's like kind of all of those things and also none of those things. Section 230 has allowed people to come into the field and not have to really worry or be afraid of the potential implications of their job in a way that I think if we see erosions to it will really impact that space in a way that I don't think anyone wants to see. It'd just be sort of an unintended set of consequences there.
Just explain, like, specifically. So, like, you would be afraid that to take something down or leave something up because you might put your entire company at risk.
Exactly. So many of these organizations, so many of these companies, especially the smaller companies, right? You know, it's one thing for all the Facebooks and the Googles to hire thousands of moderators, but in a lot of places you've got 40 or you've got 4. And if the entire livelihood of the company can be put in jeopardy because you one day took something up or took something down, just one thing is all it could take. That's a huge amount of psychological burden to place on an individual moderator, especially when we look at, you know, the moderation population in general tends to be more junior, tends to be, you know, lower in the pay bands. You know, in many companies, those end up being just sort of from underrepresented groups. It's just like we're trying to get these populations into tech. These are the entry points, right? And it's a lot, like, it's already a job that's a lot to ask of people. And then to put that additional burden on, it's something we need to navigate and negotiate as a part of the equation. And it's something that, here I am on my soapbox, it's something you never hear about when we talk, well, you rarely hear about when we talk about unintended consequences of 230 erosion. That's my bit.
Alex, do you want to talk about kind of, I would love for, I'm going to put a link to it in the and tell us a little bit about the Trust and Safety Professional Association that you just started, I think just a few weeks ago, right?
Yep, this is, we publicly launched last week, and it, I should say Adeline Kay, formerly of Pinterest and Twitter and Google before that, is our chairwoman, so, and really founder, her and Clara Sauer, the two founders with Eric Goldman, and myself and Danelle Dixon. The purpose of it is really just to provide that community and support for trust and safety professionals who are awesome. I've always loved trust and safety professionals. It's some combination of all those things that Charlotte just said, plus how much they care about people and about trying to get these very, very, very difficult decisions right. And so, yeah, that's the purpose of the organization. Our members will be everyone from the people who are doing this, you know, at the smallest companies to the people who are doing it at the major contracting entities that have taken on a lot of this work. And we also launched a foundation, the Trust and Safety Foundation, which is tsf.foundation. Trust and Safety Professional Association is tspa.info. The Trust and Safety Foundation project is a project of the Internet Education Foundation. And the idea there is there's also a lot of sort of education and research that we could do to improve the society's understanding of trust and safety. We've got a bunch of case studies, for example, to help people understand what it's like to actually make these types of decisions. But to try to get that out there and to provide more of the background. I mean, lawyers, we're spoiled. You know, we have the American Bar Association. We have all sorts of different ways to pat ourselves on the back, to get community, to learn stuff, to exchange best practices. That really doesn't exist as much in the trust and safety community as a whole.
Yeah, and I really think that this is so I'm interested actually in whether you're going to, I mean, I know it's a professional association, but I wonder, will you weigh in and be kind of a voice in the 230 debate, given what Charlotte just said and how reform of that will impact trust and safety people?
It'll really depend on what our members want us to do. We aren't really, first and foremost, a lobbying organization. I think if you took a stack ranked list from the trust and safety folks that I've talked to, number one on their list is not trying to change legislation. There's all sorts of other stuff that comes up before that, like just being able to talk to each other, to share best practices. But it will depend on what our members say and what they want to do. And I think the other thing I would add to the other thing I would say about both what I said earlier and what Charlotte just said it's not that we care about these little companies because we want like Silicon Valley to have more founders or for more people to build big companies. I care about them because, as I said before, I don't think we've got this communication at a societal level thing fixed. And if we had it, if we had a really good, robust, healthy way to do that, it would be amazing. It would be an amazing thing for everybody. And so the reason why I care about those little companies is because they might have a new take on this problem that would be useful to all of us and that would make life better. And that I think is what the trust and safety people that I've talked to, like the amazing thing, the care that they bring to the job is really trying to do that, is trying to make it so that people can communicate and can talk to each other and make communities and all the rest of that good stuff.
Yeah, in the delta that I talked about before between technologists and policymakers, I feel like this is going to play such an important role. And then I also kind of do think that there is, I mean, it is just amazing how many people still think that all of this is done by algorithm and all of this is done by like whatever that means. But all of this is done by AI, also whatever that means. And that all of this is kind of happening not by real people trying to solve real problems. And so I think that this is kind of, it's an interesting and mostly, I think, very silent perspective that has not been part of the debate. And so I'm excited to kind of see the educational initiatives that come out of this as well. So really, congratulations, AMAC. That's great. We have one last question from Adam Connor, formerly of Facebook and now Vice President of Tech Policy at Center for American Progress. Adam, go ahead and close us out.
Yeah, I just wanted to bring up this new legislation, looking at the oversight of hot tub, hot air balloons, and really exploiting that gap in the regulatory process. No, I think AMAC and Dave and Charlotte, one of the things I think about a lot is, in looking back at your previous experience and at companies and knowing what you know now, what, when you look back, do you think about what maybe if you knew what you knew now, you might have done differently? What kind of advice would you give somebody, not just in the trust and safety role, but who's building out process, maybe with the freedom of 230 or not? And I think critically, is there something you'd say to policymakers who are really struggling with always being told that like everything's a bad idea? So I know that's kind of a broad question, but I think about this a lot from my perspective and be interested to see, looking back, what kind of advice you might give, based on what you did or what you're looking forward.
Well, everything is a bad idea, so we can start there.
Yeah, but what would you have done differently? Is there anything specific? Dave, is there any part of the 90-page wiki that you kind of worked on with policy, like that you would have written differently or pushed really hard for a different outcome, harder than you did maybe at the time?
Oh yeah, all kinds of things. It's hard.
Like what specifically? What about newsworthiness or public figures?
Yeah, that's a good one. I don't think that's a distinction that works very well. But there's all kinds of stuff around how they think about hate speech and threats that I think was developing in interesting ways around the time I left and doesn't seem to have further developed, right? Mm-hmm. One thing that I think about a lot is the situatedness of verbal threats, right? Like the sort of American general doctrine around what a true threat is assumes that you're basically in a state of peace in a functioning democracy. And like, that's not true, arguably even in the United States anymore, but certainly in a lot of countries. And so you can't read something as a threat in the same way, even if the words are the same, because the meaning imparted to those words is different by the social context, right? Like if your country's in an active civil war, all threats are automatically more credible. And I mean, that's just one example, right? Like there's dozens of things where there's really interesting work to be done, really interesting thinking to be pushed on. I agree with you also that public figures as a distinction is messy because particularly for non-voluntary public figures, it just feels really bad and off to treat victims of crime the same way you would treat, I don't know, some random celebrity for the purposes of allowing people to talk about them. But the flip side to that is people who are in the news are in the news. And there's a bit of an absurdity to moderating mentions of people in the news when they're in the news. I don't have a better answer, but it doesn't feel to me like the answer we have is good enough.
I do think there's more room in the public discourse for understanding those difficulties. And I wish that companies perhaps had been upfront about that sooner. I mean, this is something I think a lot of us have been having to grapple with over the last 5 years or so is, you know, like the world changes and our level of information changes, and companies need to be not just able to, but willing to engage with those new realities from a principles-based perspective, right? Everyone needs to figure out what are their core principles, but then adapt that sort of set of policies and enforcement to new realities, and understanding like that there's just going to be trade-offs that we make. I mean, Dave and I talk all the time about like, you know, you have two bad choices in front of you. Both of them are bad. Which one is less bad? Which is the one you're going to choose that's like the least bad given your circumstances? And I think so often policies and policy outcomes are presented as like, well, you know, this is the thoughtful approach, therefore this is the outcome. And there's not a lot of public insight, especially there's not a lot of legislative insight, I think in particular, to like, hey, neither of these outcomes are great, right? Like, do we not let people talk about what's going on in the news, or do we allow everyone to talk about what's going on in the news? Then victims of crime end up in this strange place. No, neither of those are good. But until someone comes up with a better solution, maybe because the information has changed or the sort of reality has changed, we're stuck with those two bad ones. All right, let's talk about that. Let's understand that as a society.
Actually, building explicitly on Adam's question about, you know, what do you tell policymakers who are always being told their ideas are bad? Everyone's ideas are bad. All the answers to this are bad right now. There aren't any good answers. The government's answers are worse because they have the force of law and the state behind them, whereas like Twitter's answers can be different than Reddit's. So it's like, I also tell my boss all the answers are bad all the time, because frequently there aren't any perfect or even any decent answers to a given problem.
Alex, do you have any thoughts about what would you have done differently?
I like Charlotte's answer about really understanding the impacts and those impacts as they change over time. I think one of the things is people often ask me, like, do you think that the policies you know, at Twitter that are changing, is that somehow a selling out of something? And I definitely don't believe that. I think these platforms change over time, and their content policies should change with them. I think the thing I would say that I didn't do as well as I should have was particularly understanding inclusion within the trust and safety team and outside the trust and safety team. I think we did in the world. I think we did a job there. We did make an effort, but we did not put nearly the resources behind that I would have loved to in retrospect. And that very much, I think, was at my level in terms of whose fault it was. And I think that's also where I see a lot of hope. Is you look at the stuff that Kendra Albert is doing, and I think she's coming on maybe on Friday. But you look at the stuff that she's doing at Harvard to really try to bring more people into the study in academics and theory around the First Amendment and freedom of expression globally. And just thinking through, okay, what will those folks come up with? And then how can we bring that back to the practice of doing trust and safety? That's going to be awesome. And the more we have more of that type of thing, I think the more likely we are to be able to make improvements over time. Yes, thank you, Alicia. I should have referred to Kendra as they.
Yeah, Kendra, they're coming on Friday to talk about Sesta Fosta. I am super excited to talk to them, and they're also bringing on an active sex worker and sex work advocate. So I think it's going to be a fascinating conversation to close out basically an amazing week of looking forward at like what the world would look like without Section 230, to which sadly Sesta Fosta is our best example. And Cory Doctor is going to join us, and Daphne Keller will be back on Friday to talk about the forward thinking thing and pick up where AMAC left off. And then tomorrow we start at 1, not noon. Again, we'll be recorded, so we can go forward, but we're going to kind of pivot tomorrow from kind of what Section 230 has meant for the law, for agencies, for platforms, to why we're talking about it now and what it's going to mean for the future. And I think that it's going to be a really interesting kind of payoff in the next 2 days from kind of building on everything we've kind of learned from all of these different perspectives. And that's, you know, to AMAC, to your point, Charlotte, to your point, I do feel like this is just like sometimes, and it's such a bad answer, but it's never the answer that you want to end a law review article with, let me tell you, is that there's going to be, it's a slow building of social norms and education on this stuff. And it's a very laggy process, especially given the rate at which things change. I have one last question, which is kind of to the scenario that Charlotte presents of there's just two bad choices, right? You have a victim of a crime being talked about in the news, and you can't restrict people's ability to like read the news or not be able to talk about the news. But, you know, how do you save this person from the harm that is like just rained down on them from the massive amplification of these platforms when all these people are talking about the news? Is this ever going to be an answer that is solved by technology? Or changing in platforms, and there are lots of people that think that it isn't. And so I'm solidly mixed on this. AMAC, do you have any inclinations? I don't just mean AI or anything else. I mean maybe new changes to product, really broadly, frictions that are built into the platforms. What do you think?
I'm generally not a believer that technology alone solves any problems. So I would certainly add that to the list of those things. I do think there may be things that we don't know about now that where it could be helpful, and in combination with a bunch of other things, you know, the four from code and other laws of cyberspace, or other ways of doing things that could be helpful. But I wouldn't look to technology to solve anything without lots of other things.
Dave, I'll give you the last word.
Yeah, I mean, totally agree with AMAC. Often these debates about content moderation are strange to me because they presume that in an internet space we can reach more perfection than we can in the real world. And it's not clear to me why anyone thinks that is true. Right, we as a species still fight wars, but everybody wants to know why Facebook can't come up with a moderation standard that everybody likes. Seems strange to me. And if you apply that thinking, like Facebook is just a piece of technology, right? So the idea that we will automate our way out of what are fundamentally disputes about values and the nature of the good is, in my view, like clearly silly. And I actually don't fully understand why people seem to think that is possible on the internet because it involves computers, when we all go around every day accepting that real life is very, very imperfect and is a massive historical struggle to improve it. Like, I don't get why people are like, maybe it's a lack of understanding of technology that it's, you know, sufficiently advanced, it seems like magic, but that's a very strange disjunction to me that I think needs to be closed.
Yeah, wonderfully said. Balk's first law of the internet, I think, which is everything you hate about technology is really everything you hate about humanity, comes to mind here as kind of a closing idea. Thank you guys so much for coming. Thank you, Charlotte, and thank you, Daphne, for coming in just to round us out. And looking forward to seeing you tomorrow. Stay safe, guys.
Thank you, Kate.